What are your key takeaways?
Sure. Just to reiterate, I think what I said at the beginning, which is obviously you must know your judges, but particularly what the judges want, whether you're representing a petitioner or a patent owner in an IPR proceeding or a post-grant review proceeding. It's extremely important to understand the details of the case, the technology, have a deep dive. Expert testimony needs to be trial-type cross-examination testimony, and you must have corroborating documentary evidence for the expert declarations. That's one. Two, as I think we've made clear, a lot rides on the institution decision. I think given the statistics, Anita has recited some of them, and we've shown some of them. Institution decisions are just more important now than they ever were. And last, I think I would just say that watch the PTAB and the new director for potential changes to motion to amend practice. I have no inside information, and I don't know where it's going, but I would be surprised if there weren't some changes and or rulemaking by the PTAB to adjust motion to amend practice.
Thank you, Brian. Anita, some key takeaways from you, a minute, maybe 90 seconds.
Okay. So for the patent owner's response, make sure that look through everything, never take anything for granted. Make sure that the petitioner actually laid out the grounds for whether it's prior art, whether it's printed publication. The patent owner also needs to do a lot of that work to collect a lot of documentary evidence to support your arguments as to why it's not obvious to do certain things, to make it why your invention is novel and it's not obvious. Trying to sign up the prior art author if you can, and have them give you factual backup as to why the prior art is different and why the prior art does not disclose what the petitioner actually says it discloses. Second thing is, I didn't get to it, institution decision is very important. Even after the institution, read the institution decisions carefully. It gives you a lot of roadmap as to what the board is actually really wants to see in the patent owner's response. What we have done is once you have addressed a lot of the concerns of the board, for example, they say, you haven't really given me this evidence, I want to see it. That, to me, is a roadmap the board is giving you as to how you can win the petition. No, not win the petition, but save your claims even after institution. We've had success doing that by addressing the board's explicit concerns, giving them the evidence they want to see. And we have found that once you show those pieces of evidence, the board will go for you, even in the after institution. That's all.